Today is day number 20 of the YouTube challenge, and today I want to talk with you about the best way to get your case settled at mediation. So here's the problem. You show up on the day of the mediation, you see an attorney, but you either don't see a claim adjuster with the attorney, or you see a claim adjuster who appears to be 22 years old, and you kind of don't have things quite figured out at first. But after a full day of mediation, you finally realize that the most junior claims adjuster from the insurance company is there, and they don't even have authority to go to the bathroom, basically. And it's an absolute waste of time, because the key to doing well at a mediation is to have the decision maker present. And what that means is you want the person there from the insurance company who doesn't have to go to a superior and ask for authority. Because if you either have no one there from the insurance company or you have a junior claims associate, I can guarantee you that the person who is the real decision maker will not be available or within reach, and you're wasting your day at mediation. So what do you do about this? You insist in writing that the defendant bring the senior most claim adjuster to the mediation. That is non-negotiable. So here is an excerpt of our policy from fisherpedia.com that if you want to have success at a mediation, look at these two paragraphs that are right here. All insurance carriers involved must have a representative physically present at the mediation. Not available by phone, physically present. And why is that? Because it's too convenient for them to play cowboy when they're in Omaha, Nebraska in a cubicle. But if they're physically present, that means the mediator will sit down with them, discuss the weaknesses of their case, and try to get them to settle. And it goes on further, who not only has authority to settle, but also the ability to negotiate, keywords, without a superior. That means this is the person who actually will make the decision. It goes on to read, this representative shall be the senior most representative who has participated in evaluating this case and who has the final call, in quotes, in negotiations. Extremely important. I've been doing mediations for over 20 years, and I can tell you the biggest obstacle is having a junior associate there. You need the decision maker or you're wasting your time. I just went to a mediation recently where I saw a very young, maybe 25-year-old claim adjuster there from the insurance company, and I thought, boy, I've never seen that person before. And at the end of the day, they offered $1 million, and I knew going in advance that it wasn't going to be nearly enough to settle the case. And so I went back, and the mediator told me privately that the claim adjuster was the junior most claims representative from the insurance company, and their authority is limited to $1 million basically on all of their cases. So for the case to be settled for more than $1 million, it would have to be the superior of this person. And so we knew going in the case wouldn't settle for $1 million or less. So the day was a complete waste of time. Now, paragraph number 2, the personal appearance of this representative may not be waived except by the written consent of all counsel and on the affirmance that the representative will be readily available by phone at all times during the mediation. Now, you could toy with not even having that paragraph in there because you don't want to give the insurance company any outs. You want to make sure that they're going to have the senior most claim adjuster physically present at the mediation. Extremely important. One little tip addition to this, you may insist that the insurance carrier make a pre-mediation offer to you so that you know that they're acting in good faith. I went to a mediation once where the demand was $3.5 million and they show up with an offer of $100,000. If I had known prior to the mediation that they were only going to offer $100,000, I would not have even shown up. Even if I had known that that was going to be the initial offer, that's a joke. Now, get this. That was the week before the trial that mediation occurred. Their maximum offer was $100,000 on a case with a settlement demand of $3.5 million. I show up at the first day of trial, and before jury selection even begins, they offer $1.3 million and the case settles. So later that day, I called the mediator, and he said, do you realize that the maximum offer you got was $100,000 at mediation, and on the first day of trial, it settled for $1.3 million. How do you explain that? And the mediator said, John, you know that when you go to mediation, you accept a fraction of the true value of the case. And that is total BS. Because I would not go to mediation if I was accepting a fraction of the case. I might save a little bit in terms of the litigation expenses, but really not much. And when you're 1 week away from trial, you're really not saving anything on trial expenses. So, if I'm accepting a fraction of the real value of the case, then mediation is a complete and utter waste of time. The key to avoiding this, number one, make sure the senior most claim adjuster is physically present at the mediation, and number two, insist on a pre-mediation settlement offer so that you know that the insurance company is acting in good faith in going to mediation and not simply wasting your time and trying to find out what your real claims are. So that's it for today. I will see you tomorrow on the YouTube challenge. Take care, everybody.